Hello students, hope you are all doing. As you know that we have been discussing the case study of the business law chapter. Especially we have covered two parts in previous session as to Indian Contract Act. In this video we are discussing the Sale of Goods Act related questions. So students, please understand the importance of case study analysis. So for a CA foundation student, you should have a practical application of the provisions of law. See, unless you just memorizing the provisions of law will not take you anywhere. So please understand that case studies will help you to understand the legal principles as such, like for example in the Companies Act or for Contract Act, like how a particular provisions are applicable to a given practical situation. So this case study analysis helps the students in understanding the substance of the law rather than just memorizing it. So what happens when you are analyzing a case study? It requires a particular student to break down the facts, identify the provisions of law, and apply the legal principles, and thereby improving the analytical skills. So this particular step will help you as a chartered accountant in future. Also, it will help you to resolve the complex challenges and the critical dilemmas that you have to face in the career. So while analyzing the case studies, you have to structure the answers. Like for example, you have to understand the facts, you have to understand the legal provisions applicable to a particular case, and analyze the situation and draw the conclusion. So, in nutshell, for analyzing the case studies, is that first thing you should understand the question first. So understand the facts first and identify the core issues in the particular given. So then identify the law or provision which is applicable to the particular scenario or particular case. And third one, wherever there is a judicial precedents or wherever there is a case laws applicable, you please cite it in your answers. And after applying all these provisions of law, judicial precedents, and applying those principles to a particular facts of the case presented in the particular case study, and then you can summarize the findings and produce the clear cut answer by drawing the conclusion as to what is the solution. So this is the approach that you have to follow while solving the case studies. And please remember that merely memorizing the provisions of law will not help you. Understanding the practicality and how the particular provisions of law is applied to a given situation. So that way it will help you to understand and have the authority over the provisions of law. So let us start understanding the case studies one by one.
L Limited sells a machine to M and Company on credit basis. The agreement states that ownership of the machine will remain with L Limited until the full payment is received. L Limited delivers the machine to M Company. Before the full payment is made, M Company faces financial difficulties and declared insolvent. Can L Limited recover the machine? So in this case, the L Limited has reserved the right of disposal, isn't it? They have reserved the right of disposal. As per section 25, when the seller reserves the right of disposal of specific goods, the property in the goods transfers only upon the payment. If the payment is not met, the property in the goods remain with the L Limited. So this is covered under section 25(1). So in this case, L Limited can recover the machine because M Company has not fulfilled the condition of making payment. The next case is Messrs. C orders a custom made dining table from a carpenter, Mr. D. The price is agreed upon. Mr. D needs to polish the table before it is ready for delivery. Before polishing is completed, C pays full price. However, Before delivery, a fire breaks out in the D's workshop and the table is destroyed. Who has to bear the loss? Students, in generally property in the goods passes with respect to the specific goods which are not in deliverable state only upon when such action is done. Meaning, when it is put into the deliverable state, only then it is transferred, provided the notice has been given to the buyer. So, if the goods are not in deliverable state, it is the responsibility of the seller. It has to put it to the deliverable state, and the buyer should be given notice thereof. If not put into the deliverable state and buyer is not notified, then the risk remains with the seller only. So, in this case, loss due to fire must be borne by the carpenter, Mr. D. So this is basically section 21 talks about this when property in the goods with respect to the specific goods which are not in deliverable state. So in such case, the property passes only when it is put into the deliverable state and the buyer has been given the notice thereof. Moving on to the next case study, Lakshmi purchased a water purifier from Aqua Health Limited. The salesperson did not make any specific claims about the product, but Lakshmi assumed that it removed all impurities, including heavy metals. The product brochure also did not mention capabilities regarding heavy metal filtration. After using it for a month, Lakshmi had the water tested and found it still contained arsenic, which was present in her local water supply. She wants to return the product, claiming breach of implied warranty about the quality of the product. Students, section 16.2 talks about this. Section 2 talks about this. It is generally the seller's responsibility to ensure that goods sold by him are of merchantable quality. So, what is merchantable? If it is purchased for personal use, it has to be fit for the personal use, or if it is meant for resell, it should be fit to resell. So, it has to be merchantable quality. So that will serve the buyer's purpose. However, seller cannot be made liable if the goods purchased are for a particular purpose and it is not mentioned by the buyer to the seller. No doubt, the implied condition that the goods shall be reasonably fit for such purpose. So it has to be reasonably fit for the purpose which is meant for. If, however, if it is the specific purpose is not mentioned by the buyer, then seller will not be liable. So if the buyer relies wholly on the seller's skill and judgment, seller is liable, no doubt, for the merchantable quality, but for the specific reasons or specific purpose, if the buyer is purchasing, it has to be brought to the notice of the seller. Otherwise, the buyer is responsible for the any loss. So in this case, Lakshmi did not specifically mention about the requirements, so she cannot return the product claiming the breach of implied warranty. As also there is no implied condition also that the purifier would remove heavy metals. So Lakshmi cannot return the goods in this case. Moving on to the next case study, Rohit entered into a contract with Mohan to purchase his vintage car. So Rohit is a buyer, Mohan is a seller for 12 lakh rupees. The agreement stated that Rohit would pay 2 lakhs as advance and take possession of the car immediately and pay the remaining amount in the monthly installments of 1 lakh rupees each. The agreement also stated that the ownership of the car would be transferred to Rohit only after full payment is made. After paying 8 lakhs in total, Rohit faced financial difficulties and could not pay further installments. Mohan repossessed the car. Rohit claims that Mohan cannot repossess the car as he already paid 2/3 of the price. Decide whether Mohan's action of repossessing the car is valid. Students, what happens with respect to agreement to sell? Agreement to sell, the property in the goods will take place at a future date upon fulfillment of some conditions. So the key difference between agreement to sell versus sale is that the ownership transfers immediately with respect to sale, whereas in the case of agreement to sell, the transfer of property takes place only at a future time upon fulfillment of some conditions. In this case, the parties like Rohit, who has defaulted in payment, Mohan had the right to repossess the car because the ownership is not transferred. So ownership is not transferred, hence Mohan can recover the goods. So the contention of the Rohit is not correct and not valid, because in the agreement to sell, the ownership is not transferred immediately. Hence, the ownership is still with the seller Mohan. So Mohan's action of repossessing the car is very much valid. Moving on to the next case, Vijay entered a mobile phone shop and selected a smartphone priced at 25,000 rupees. After examining the phone, Vijay handed over the money to the cashier. As the cashier was preparing the receipt, the phone slipped from the counter and got damaged. The shop owner refused to either provide a new piece or refund the money, claiming that the ownership had already passed to Vijay. Analyze the rights of the parties. Students, what happens in the case of specific goods or ascertained goods? Specific goods or ascertained goods, what happens? The property in the goods passes to the buyer uh, as with respect to the intention of the parties, based on the intention of the parties. If the intention of the parties is absent, matlab there is no specific express agreement, then property in the goods with respect to specific and ascertained are immediately transferred. Generally, an unconditional contract for the sale of specific goods which are in a deliverable state, the property in the goods passes immediately, regardless of whether the payment is made or not and whether the delivery is happened or not. So, irrespective of payment or delivery, the transfer of property in such cases, it is transferred. So, in this case, Vijay has already selected the phone and he has already paid to the cashier, and the phone is already in a deliverable state, and the shop has already accepted the payment, which is preparing the receipt. So all these situations showcase that that property in the goods has transferred to Vijay, even though the physical delivery was pending. So handing over the receipt and handing over the phone was pending. So under these circumstances, Vijay has got the ownership rights with respect to the goods. So Vijay cannot demand a new phone because the risk lies with the Ajay in such cases, as the risk has already passed to him. However, on a contrary note, if the damage or destruction has happened due to the seller's negligence or misconduct, then seller is liable. So in the absence of any such information in this question, it is presumed that Vijay is liable. Moving on to the next case, Rajesh agreed to sell 100 kg of premium basmati rice to Suresh at 120 rupees per kg. The rice was to be delivered next week after processing. However, before delivery, the entire stock of rice was destroyed in a fire accident at Rajesh's warehouse. Suresh demands delivery rice of rice or compensation. Analyze the situation under the Sale of Goods Act. See what happens if the goods with respect to specific goods perishes without the seller's fault. What happens when in the case of sale of goods, the property in the goods immediately transfers to the buyer, but if the goods perish without the seller's fault before the risk passes to the buyer, the agreement becomes void. So based on the based on the provisions of law with respect to the destruction of subject matter. So since the rice was destroyed in a fire accident before delivery, and assuming it is not due to the Rajesh's negligence, the seller's negligence, assuming it there was no default or no negligence of the seller's part before delivery, and before the property is also passed on to the Suresh, the agreement to sell becomes void. Hence, Rajesh is not liable to deliver the rice or pay compensation to Suresh. So, therefore, Suresh cannot legally demand delivery of rice or compensation, because in this case, this is a case of agreement to sell. So agreement to sell, where the subject to some conditions at a future date, it is going to be transfer of property based on the contract. But in this case, the property in the goods got destroyed before delivery. Moving on to the next case study. Tina, who is not the owner, sells a bike to Ramesh without the permission of the real owner. So Ramesh buys it in a good faith. Later, Aman claims ownership and demands the buyback. Students, this is a case of sale by a non-owner. Section 27 talks about this. A person cannot transfer a better title than he himself has, unless the owner has by conduct or by his conduct precluding that the denying the seller's authority. So basically, the Tina is not the owner and had no authority to sell. But even though Ramesh has bought the bike in a good faith, even though Ramesh has bought in a good faith, the sale is void because of because of the no authority to sell, and the true owner is actually in this case Aman, isn't it? So in this case, Aman can rightfully claim the bike, and Ramesh's remedy lies against the Tina. So in this case, yes, Aman can claim the bike back. Moving on to the last case, Ravi contracts to sell a specific painting to Raj for 50,000 rupees. Both agree that the painting will be delivered after an art exhibition ends. The painting remains with the Ravi till then. So before delivery, the painting is damaged in a fire. See, with respect to the specific goods, the ownership transfers at the time parties intend to be transferred. The intention can be inferred from the contract terms or conduct of the parties and the circumstances. In this case, it is clearly evident that the parties, they have identified the painting, the specific goods. Both the parties have intended to transfer the ownership after the exhibition. So after the exhibition, the property in the goods is being transferred. So in such case, ownership had not yet passed to the buyer, that is Raj, and the risk is remained still with the Ravi, and Raj is entitled to refund. So Raj in this case entitled to refund, as he has not become the owner in this case. So I hope you all have understood this case studies. We will be further discussing the another set of case studies in our upcoming session. So till then, keep learning, and please don't forget to like, share, and subscribe our channel Lathor Academy. Thank you.